Thank you very much. I'm not wearing a tie today, but I suppose that the weather is a plea in mitigation to a certain extent. I suppose I wanted to just give an overview of a sort of potted history, maybe, of international law and what it means and how it's evolved and what the triple lock and the move to abolish the triple lock means in that context. So we're used to hearing about international law in a certain way as something that means a particular thing in terms of the United Nations, the Security Council, and so on and so forth. And I suppose it's had a long history. It didn't always have that solidity of a single body like the United Nations and the International Court of Justice to underpin it. But powerful countries always sought the approval and, I suppose, approbation of international law in how they defined their actions. But traditionally, if you just break down the word maybe, inter and national, international law was always defined by the nation. And who was the nation? Traditionally, it would always have been the powerful countries, the imperial powers, who enjoyed personhood in international law. And if we think back to our own history, our invasion in 1169, that was authorized by a papal bull, allegedly, from Pope Adrian, which was the nearest thing to international law you had at the time. So that was how international law was for many years. It was always concluded, I suppose, in ways that were favorable to the powerful states, because there was a huge inequality of bargaining power between those countries as subjects of international law and the subject peoples, if I can put it that way. But something quite strange happened with the two world wars, because after the Second World War, you had a situation where there were two superpowers, neither powerful enough to defeat each other. And you had the creation of the United Nations, which was predicated on the desire to avoid a Third World War and predicated on a desire to create institutions where all countries were equal and had equal rights, not to be invaded and not to be subject to crimes against humanity. So what you saw was a real revolutionization of international law with the advent of the UN and with decolonization in particular in the 1960s and so forth. And what happened was international law came to be turned on its head to a certain extent, whereas once it might have been used as an instrument that was favorable to the interests of imperial countries became subject to international law. We saw this, for example, probably one of the earliest and most famous cases was when President Ortega took President Reagan to court before the World Court over his crimes against the Nicaraguan people by backing the Sandinistas. And it was a huge watershed moment, because here you had tiny Nicaragua defeating the United States of America before the World Court. And it was a shocking defeat for imperialism in terms of world opinion. So what we've seen, that was one example, but I suppose the trend of international law becoming embarrassing for imperialism and becoming a fetter that imperialism wanted to throw over is something that we've seen increasing since then, now that you have so many countries who are prepared to invoke their rights as subjects of international law. We've seen, in 1999, we saw something that would probably have been inconceivable during the Cold War, when Yugoslavia was attacked, and there was really no legal basis or even pretense to a legal basis for that. You instead had a concept of this was legitimate but not lawful. Now, what does legitimate but not lawful even mean? But essentially what it meant was the big powers who continued to exist after the Cold War arrogated to themselves the right to use force whenever and wherever they wanted. We saw this again with the invasion of Iraq in 2003, when the powerful, the US, the UK, sought simultaneously to invoke the UN because Saddam Hussein had not complied, allegedly, with various UN Security Council resolutions to justify the war, even though the war was completely contrary to the UN Charter. So what you've seen in the recent 20 to 30 years is this attempt to move away from international law and I suppose pick and choose what is and isn't lawful, but by imperial powers using their own definitions rather than relying on international courts, such as the International Court of Justice, because that's really the core of all of this. The rule of law has at its heart the ability of an independent court or tribunal to determine what is or isn't lawful. Otherwise, you can just pick and choose incessantly. And what we've seen in recent years is the move to use this expression, a rules-based order, instead of international law. Now, if I'm advising a client on something as elementary as a residential lease, and they're being told by their landlord they haven't complied with the rules, what do I want to see? I want to see what the rules are. I don't know what the rules are that underpin this rules-based order. So this rules-based order is, I would submit, a sort of sleight of hand that's developed in the last few years to try and formalize or give a sort of veneer to this abandonment of international law. And it's a very, very concerning development. It sort of shows that countries can't admit that they're abandoning international law, but they are doing so, and they're trying to pick and choose what is and isn't lawful. And so I suppose that's maybe a somewhat long backdrop to Ireland and where that leaves us with the abolition of the triple lock. I mean, first of all, I would say we have a very important history in terms of international law. I mean, Sean McBride, SC, was a leading advocate of international law and denuclearization. When Frank Aiken's Nuclear Non-Proliferation Treaty was agreed in 1968, that created binding legal effects, and it was held to do so by the International Court of Justice in the advisory opinion on nuclear weapons in 1996. So we as a small country have and it kind of touches on what Francesca was saying, we have a great potential to put rights above profit and to be the conscience of the world as we should be, and as President Higgins so ably was. But unfortunately, we're seeing a move away from that with this move to abolish the triple lock. The rationale is we are being constrained by the UN Security Council, and we hear these cliches about Putin's veto or Xi's veto, and this is just a certain way of framing the desire not to be bound externally. The government doesn't want to be bound by an external court or an external body, such as the United Nations or the UN Security Council. But as with the rules-based order, they're not willing to say it explicitly. So in the bill that seeks to abolish the triple lock, they're saying all missions will comply with international law, even though we have no way of establishing how they're going to comply with international law in the absence of any objective check, which, as I say, is what's really core to ensuring international law is adhered to. The United Nations, the International Court of Justice, there has to be an external benchmark to prevent people just resorting to this rules-based order and picking and choosing which rules they're going to adhere to. So that's, I think, the heart, from a legal point of view, of the concern with the abolition of the triple lock, before we even get into the issue of constitutionality and the fact that this was a referendum commitment. I think that the abolition of the triple lock is part of this general move away from international institutions, away from international law, and to put us in a situation whereby we're unable to stand up to the dictates of certain powerful countries. I mean, how, frankly, can we trust the government to believe that international law will be adhered to with these missions, these unspecified missions to unspecified locations, when they may be very robust in condemning Russia's illegal invasion of Ukraine, but when it comes to President Trump literally threatening to annihilate an entire civilization, they couldn't utter a word of protest. So I believe that we would be dupes to believe them when they say that they will adhere to international law. I believe that retaining the triple lock is essential to ensuring that our troops do not go on missions that are contrary to international law. I think it's about accountability. International law is not perfect, but as Eamon de Valera said when commenting on the League of Nations, which he did so much to support, the alternative is the law of the jungle. And as a small country in particular, we have to avoid that. So that's really my submission. And I think we abandoned the triple lock at our peril.